Today, I'm joined by Guiles, a partner with Coughlin Gerhart, who regularly assists those with estate planning matters. Caroline, thanks so much for being here.
Thank you for having me.
Yeah, so today we are talking about a topic that many people may not realize can create complications, and that's owning property outside of New York State. So maybe just tell me why that's important.
Absolutely. It's a question I get a lot from clients that maybe they have real estate outside of New York State because they inherit it, they have a vacation home, or maybe even investment property outside of New York State. What folks often don't realize is that if you own an out-of-state property, you might actually have to do an additional probate proceeding after someone passes away.
So now, why would someone need to probate a will in another state?
Generally, when someone passes away owning real estate in multiple states, they have to probate their will in every state they own real property. Their initial probate is done in their home state where they died a resident, but we do something called an ancillary probate in every state, typically where they own real property.
I can understand why people would want to avoid that. Now, what are options available to them?
There are generally three options I suggest to folks to help avoid an ancillary probate. The first would be a revocable trust. The second would be a life estate deed. And the third option is something we call a transfer on death deed.
So let's start with, what is a revocable trust?
A revocable trust is a legal document that allows us to transfer ownership of an asset or property into the trust name itself, out of that individual person's name. We call this revocable because the trust can be changed during the creator or the grantor's lifetime, and we can change the trust any way they would like. When the grantor passes away, the property does not go through probate. It goes according to the trust document itself, which again helps us avoid that ancillary probate.
So now another option you mentioned was a life estate deed. What is that?
Yes, a life estate deed is a deed that allows someone to retain life use. So the property is there so long as they're alive, but upon their deaths, it would transfer to someone else or multiple other people who they select. Typically, the owner of the life estate deed is called the life tenant, and the person who receives the property after their death is called the remainder man.
So now the third option that you had mentioned was the transfer on death. What was that?
A transfer on death deed, or a TOD deed, sometimes folks call them, allows a property to be designated with a beneficiary, similar to maybe designating a beneficiary on a retirement account or a bank account. This will automatically transfer to a person when that individual passes away. A new deed doesn't have to be done.
Yeah, now those are three options. Is there a best option available for everyone?
Not necessarily. Each option has advantages and disadvantages, and the best choice depends on factors like the type of property, where the property is located, family circumstances, tax considerations, and long-term planning goals. So it's very, very important to speak with an attorney to speak about your specific situation and what the best approach may be. At Coughlin Gerhart, we regularly help clients evaluate all these options and create an estate plan designed to minimize the complications and make things easier for their loved ones.
Well, thank you so much for sitting down and talking about this with me. I really appreciate it.
I appreciate the opportunity.